All right, good afternoon. We are back on the record in case number 26-90447. Mr. Wofford, you're still under oath.
Yes, Your Honor.
Counsel may proceed.
Thank you, Your Honor. Jonathan Friedman from Glen Ager for the preferred shareholders. And may I approach
Yes.
to hand the
Yes.
witness a document? Thank you. Good afternoon, Mr. Wofford. Nice to see you again.
Good afternoon.
Do I need to give one of your people presenter rights?
Oh,
Yeah.
I think we set that up during the break, Your Honor.
Got it. Okay.
Mr. Wofford, you support approval of the proposed plan, correct?
You do.
And under that plan, you understand that all assets are removed from QVC Group and its preferred shareholders are left with nothing, correct?
I understand that there's dissolution of QVC Group, yes.
Could you speak up a little?
I understand that QVC Group will be dissolved.
And its preferred shareholders will be left with nothing, correct?
The preferred shareholders will receive no recovery.
And you understand that under the plan, the basis for removing assets from QVC Group is the settlement of the intercompany claims we've been discussing?
I understand that's one aspect of it, yes.
And you understand further that these intercompany claims we've been discussing are not claims that have been filed in any court, but just that the settlement was extracted based on the threat of these claims?
My understanding is the disinterested directors came to a solution of how to settle the claims amongst themselves, yes.
The claims were never filed in any court?
Not to my knowledge.
And you understand that there were various investigations that assessed these potential claims against QVC Group?
Potentially.
You've given testimony about that today, correct?
Yes.
But despite these investigations, you're not aware, sitting here today, of anyone having made a determination that any of those intercompany claims against QVC Group were likely to succeed if litigated, correct?
I am not aware, no.
In fact, determinations aside, you're not aware, sitting here today, of anyone even asserting that those intercompany claims were likely to succeed if not litigated, correct?
Not that I'm aware.
Mr. Wofford, you have in front of you your declaration that has been admitted into evidence. It has the marking PX347. Do you see that?
I do.
And you were deposed in this matter on Friday, 7 days ago?
Yes, I was.
And you have submitted this declaration since then, 2 days ago, correct?
I believe so, yes, correct.
And I would remind you to speak into the microphone.
Sorry, I apologize.
In that declaration, you assert that the plan complies with the applicable provisions of the bankruptcy code, correct?
Correct.
I notice that in reviewing what you identify as the applicable provisions of Section 1129 of the Bankruptcy Code, you discuss on pages 10 to 13 of your declaration subsections A4, 5, 6, 9, 11, 12, 13, 14, 15, and 16. Is that right?
Can you repeat the question? What's the question?
I noticed that in reviewing what you identify as the applicable provisions of Section 1129, you discuss on pages 10 to 13 of your declaration subsections A4, 5, 6, 9, 11, 12, 13, 14, 15, and 16. Is that right?
That is correct. This is my declaration. This was prepared by counsel.
You played no role in preparing this declaration.
I reviewed the preparation. I reviewed the document.
And you confirmed its accuracy?
I defer to counsel, but I believe it is accurate.
And you have a reasonable basis for affirming that what is in there above your signature is accurate?
I believe on advice of counsel it is accurate. And
your declaration does not discuss or even mention, among these many subsections, subsection A3 of section 1129, which requires that the plan be proposed in good faith. Isn't that a fact?
I'll take you at your word on that.
Likewise, your declaration doesn't discuss or even mention subsection A10 of section 1129, which requires acceptance of the plan by an impaired class. Isn't that a fact?
I wouldn't take you at your word on that. I'll defer to counsel.
Objection, Your Honor. The declaration was prepared in consultation with Glenn Ager on what were going to be the uncontested provisions of the plan. And they confirmed that they were the uncontested nature of the plan. So I'm surprised we're having cross-examination about what are the uncontested natures of the plan. Mr. Wofford's live testimony is presented for the contested natures of the plan.
I'm not sure if there was objection to a particular question I asked, but I'm moving on in any event. Let's talk about the intercompany claims, Mr. Wofford, whose settlement was the justification for removing assets from QVC Group, okay?
Okay.
One category of intercompany claims is based on dividends paid from QVC Inc. to QVC Group, correct?
I believe so.
And as you testified, you've been the CFO of QVC Inc. since March of 2023, correct?
That is correct.
And again, as you testified, in addition to continuing in that role, you've also been the CFO of QVC Group since April of 2025, correct?
That is correct.
You understand that the dividends that have been looked at as potentially giving rise to intercompany claims began with the December 2022 dividend that you testified about?
I'm not sure if those are the only dividends at the beginning, but I understand those are part of it, yes.
And you understand that the dividends that are being looked at in connection with the intercompany claims continued past March of 2023 when you became CFO of QVC Inc., correct?
I believe so, yes.
And you were aware of those subsequent dividends at issue that were paid while you were CFO, correct?
There were dividends paid while I was of QVC Inc., correct?
And you were aware of them?
I was aware of the dividends.
And you didn't object to them?
I did not object to them.
And you understand that QVC Inc. obtained a solvency opinion in December of 2022 from Kroll confirming its solvency before paying the December 2022 dividend at issue?
I believe there was a solvency opinion in December of 2022, or leading up to the December 2022 dividend.
And you also understand that QVC Group, which we sometimes refer to as Topco, obtained numerous additional solvency opinions from Kroll confirming its solvency through the period of the dividends, correct?
Yes, they did.
And you testified on direct that you provided input for those solvency opinions, correct?
I did provide input for those opinions, yes.
And you believe that those solvency opinions were executed in good faith, correct?
I believe the opinions were executed in good faith.
And not only that, you believe that in addition to being executed in good faith, you have no reason to doubt them, correct?
I did not opine on the solvency of the business.
You are familiar with the solvency opinions, correct?
I am familiar with them.
And you have no reason to doubt them, correct?
I believe they were executed as expected, and I have no reason to doubt their validity.
The dividends from QVC Inc. to QVC Group in 2022 and 23 were approved by the board also of QVC Inc., correct?
It's my understanding. Or it would have been of QVC Group. There was no board at QVC Inc.
But approved by the board.
Approved by the board, yes.
And Mr. Wofford, sitting here today as CFO of both entities, QVC Inc. and QVC Group, you believe that that the payment of these, in making these dividend payments, they complied with the company's obligations to each other, correct?
I believe they complied with obligations under a credit facility and the ability to make the dividends. I don't think there was an obligation to make a dividend.
I'd like to talk with you a bit about the tax payments as intercompany payments that you testified about earlier.
Referencing the tax sharing agreement?
Payments pursuant to the tax sharing agreement, yes. So you understand that in addition to the dividends we've been discussing, another category of potential intercompany claims relate to these payments under the tax sharing agreement.
I understand.
And you understand that QVC Inc. and QVC Group are both parties to that agreement.
Yes, they are.
And pursuant to this agreement, QVC Inc. calculates its tax obligation and transfers funds to QVC Group.
That's correct, yes.
And you understand it has been suggested that these payments might give rise to intercompany claims against QVC Group?
I understand over time there was an amount remitted to QVC Group that was greater than the obligation from Group, and that could give rise to a potential claim.
But your understanding is that all payments between QVC Inc. and QVC Group were in compliance with the tax sharing agreement, isn't that right?
My understanding is all the payments from Inc. to Group were in compliance with the tax sharing agreement.
Thank you. You also spoke a bit on your direct examination about the deferred tax liability issue, correct?
Correct.
You understand that another related category of the potential claims, the potential intercompany claims at issue, relates to potential deferred tax liability and the suggestion that QVC Group might share responsibility for it if it materializes?
I understand that, yes.
On your direct examination, you looked at an SEC filing and a disclosure statement that characterize that risk, correct?
Correct.
And the words that the company chose to characterize that risk in both the SEC filing that you signed and the disclosure statement were will not materialize, correct?
The company's position is that the deferred tax liability will not materialize.
Right. Those documents, including the SEC filing you signed, did not characterize the company's position as believing that the tax liabilities should not materialize, correct?
We characterize it as will not. We included a risk disclosure. It says that may not be the case.
Thank you. And in addition to it being the company's position that this potential tax liability will not materialize, it's also your position that this tax liability will not materialize, correct?
That is correct.
Mr. Wofford, you were aware of the dividends and the tax payments pursuant to the tax sharing agreement that we've been discussing. But prior to the bankruptcy filing, you had no reason to believe that those payments might give rise to legal claims, correct?
I had not considered legal claims associated with the payments.
you knew about the payments, correct?
Correct.
But it hadn't occurred to you and no one had told you that they might give rise to legal claims?
I had not spoken with counsel about it.
And nothing about the payments with which you were familiar suggested to you that they might give rise to legal claims, correct?
Mr. Friedman, I'm not a lawyer. I'm not sure what would give rise to legal claims and what wouldn't.
In fact, even as recently as April 15, less than 2 months ago at this point, you had no reason to think that these payments might give rise to legal claims, correct?
I was unaware if whether they would or would not.
Isn't it a fact that you did not even hear about these potential intercompany claims until after the filing of the bankruptcy?
I was aware there were intercompany transactions that were in discussion. I didn't know what specific claims there could be, something such as fraudulent conveyance or something like that. I'm not a lawyer and wasn't aware of what the specific legal claims could be.
Mr. Wofford, you were aware that there were intercompany payments that were being discussed,
Very aware.
but you were not aware that those payments were being discussed as potentially giving rise to intercompany claims until after the bankruptcy, correct?
That's correct. I didn't know what those claims could be.
Do you still have in front of you the big binder that you
Yes, sir,
were
I do.
discussing during your direct exam? So let's look, please, at DX437. This was an initial proposal regarding what the terms of the plan might look like, correct?
Correct.
And this plan, as you walked through on direct, this proposed plan provided that QVC Group preferred holders would receive the residual cash at their respective entities and retain their existing ownership of Cornerstone, correct?
That is correct.
And this document characterizes that proposed plan as the company's proposal, correct?
The company's framework proposal.
Turning to the first page of this exhibit,
Yes, sir.
there's an email from Patrick Griffin at Evercore. Do you see that?
1 second, sir. Yes, I see that.
And in that email, he writes, please find attached the company's proposal. Do you see that?
I do.
He doesn't say the company's framework. He says the company's proposal, correct?
That was the draft of Patrick. That was Patrick's email draft, yes.
And if you turn to the proposal itself, which is 4 pages into the exhibit, the page that says Project Courts, are you there?
I do.
You're looking at that page, Mr. Wofford?
Yes.
And you see that on that page, the title of the presentation, it is described as company proposal, correct?
It is. I also see 2 pages down, the first bullet, it says the term sheet contains the framework for a comprehensive restructuring.
Now, Mr. Wofford, you understand today that various groups, including disinterested directors, were charged with investigating these potential claims, right?
Yeah, I understand.
But even though you have been CFO of QVC Inc. since March of 2023 and QVC Group since March of 2025. No one discussed them with you until your counsel told you about the claims post-filing. Isn't that right?
That's correct.
Thank you, Mr. Wofford. No further questions.
Does anyone else wish to cross-examine Mr. Wofford? All right, redirect Mr. McCain.
I'll be very brief, Your Honor. Mr. Wofford, Mr. Friedman, counsel for the preferred, asked you a series of questions with regards to the company's position about the deferred tax liability and whether it'll materialize. Do you recall those?
I do.
All right. The company's position that it will not materialize, but that others might disagree. In light of your role working with tax professionals, do you have an understanding of sometimes when should not and would not take different meanings with regards to a tax opinion as opposed to the words that we might more casually or colloquially use with regards to will not or should not?
Yes, I do have an understanding of that, yes.
All right. By stating in the SEC filings the company's position that it will not materialize but that others disagree, was it your understanding that the company was taking a heightened position with regards to whether it will not materialize in terms of a probability as opposed to whether it should not materialize in terms of a probability?
No, my understanding is our belief in what we received in terms of our PwC opinion is that we believe it should not arise.
Has anything changed with regards to the company's view as to its level of confidence with regards to that issue?
None at all.
All right. Mr. Freeman asked you a series of questions about your understanding of what claims or potential claims exist as it relates to the intercompany issues. You recall that, sir? At one point in time, you said you're not a lawyer. You recall that?
I do.
All right. When you were responding to Mr. Freeman's questions with regards to claims, are you talking about specific legal claims?
I was talking about specific legal claims.
All right. So what did you mean when you say you learned post-petition that you learned of which potential claims would be asserted?
The understanding of what those intercompany positions what claims they could give rise to. One of those, and I'm using that because I think that's the one I remembered, was fraudulent conveyance.
Right. Prior to that, at the start of this restructuring, is back in March of 2025, were you aware of whether there might be intercompany issues?
I knew that QVC Inc. and Group had moved significant amounts of cash and capital between the different entities, so I knew that could potentially become an issue.
Right. And was that one of the reasons why you went through the exercise of bringing in essentially the directors?
Definitely.
Right. And were you involved, other than making information available, in their evaluation of those issues from a legal perspective?
Not at all.
I don't have any further.
Mr. Friedman, anything further?
Just briefly, Your Honor.
Go ahead.
You recall my taking your deposition just 7 days ago, Mr. Wofford?
I do.
Do you recall my asking you,
Page in line, you got to give me a copy. Thank you.
so looking at page 80 of your deposition transcript, starting at line 4 and going through line 17. I'll wait a minute for this to come up on the screen.
Zero.
Do you recall my asking you whether prior to April 15 you were aware that
Here we go.
Do you recall my asking you a week ago whether you were aware that prior to April 15, 2026, that the company was investigating potential claims relating to dividends and tax payments?
Yeah, I recall. I read this.
And do you recall testifying that you were unaware of any potential claims at that time?
I do.
And moreover, that you realized that there were dividends and tax payments between the entities?
Yes.
But do you recall further testifying that you had no reason to believe that those payments you were aware of might give rise to legal claims?
Correct. I didn't have an understanding what legal claims could arise from that.
But Mr. Wofford, not just the specific legal claims that lawyers can opine on, you had no reason to believe that these payments would give rise to any claims, correct?
I was unaware of any potential legal claim that could come with that. That was the question that I see on line 12.
Okay, thank you. No further questions.
Mr. McCain?
Nothing further, Your Honor. If we could release Mr. Wofford, that'd be great.
You're released, Mr. Wofford.
Thank you, Your Honor.
Your Honor, I think I heard Mr. Glenn say that one of our four witnesses he had no questions for whatsoever. And in the spirit of allowing people to, like, no disrespect to Houston, maybe leave to the extent they want to go home on a Friday, maybe it makes sense to go out of order and call that witness.
Right.
If you're not here, you lose. I apologize, Your Honor. I'll escort Mr. Wofford out, and we're going to proceed forward, I think, with the Evercore witness, unless that witness gets here. You want to just check? I'll give you 2. Your Honor, can we take a 2-minute break?
Sure.
Thank you, Your Honor.
Thank you, Your Honor.
All right, we'll be back at 3:07. We'll be back at 3:15.
Thank you.
That's a